Thank you, Ben, for clarifying this. It's my pleasure now to introduce to you Roberto Mastroianni of the University of Naples, who is talking about what has actually changed. Are there new perspectives of Ombuds review after the Treaty of Lisbon? And he is going to touch upon various areas which so far, previously to Lisbon, had been outside, officially offices and agencies, of course, but less practically so, but importantly, former second pillar matters, and looking forward to your discussion. Thank you.
Thank you very much for the invitation, first of all. I'm delighted to be with you to celebrate the European Ombudsman coming of age somehow. Thanks to the Ombudswoman as a person, to the Ombudsman as an institution, and to all the organizers of this conference. I was given the task of entertaining you, and I understand fully that I am one of the last obstacles between you and freedom, but I'll try to stick to the time limitations that have been given. On the new perspectives of the European Ombudsman opened by the Lisbon Treaty, it's a very broad, as you understand, topic, so I'm trying to focus on some specific questions, dividing this presentation into two parts, as you see from this slide. First, taking a look at the revision in the Lisbon Treaty, and also trying to look also beyond the Lisbon Treaty revision to highlight some possible new changes of the Ombudsman role. And the second part, to take a look more deeply to the European Citizens Initiative as a demonstration of the recent approach of the European Ombudsman vis-à-vis general questions. As to the revisions in Lisbon, I'll be very brief on this because I'm aware that many of you know about this much more than me, but let me just remind that the general rules on the competence of the European Ombudsman has been slightly modified. Article 20 and 24 of the Treaty on the Functioning of the European Union have not been modified, so there's nothing new on this part of the treaty, whereas Article 228 has encountered some changes which broaden the European Ombudsman mandate. So I'm dividing this part of the presentation with rules that formally and directly impact on the Ombudsman activity, and other rules which indirectly modify the previous rules. As to the first limb, let's remind that the subjective, so to speak, mandate of the Ombudsman has been broadened. Article 228 now makes a reference to not only to institutions and bodies, as in the previous text, but also to offices and agencies coming into the scope of the European Ombudsman mandate. And as the Ombudsman himself stated in one of the latest annual reports, there is a list of institutions in Article 13 of the Treaty of the European Union. There's not a list of bodies, of offices and agencies. I guess the solution was to give this to give to these words a very broad interpretation, including not only bodies established by the treaties, but also bodies set up by legislation or in general by decision of the institution, as in the case of the European Convention, or even bodies established by international treaties to which the European Union is a party. And considering the recent proliferation of agencies, I will start to give some examples of how the European Ombudsman has interpreted its new role vis-à-vis the agencies. The list is very long, as you know, but I'm just citing here a couple of initiatives of the European Ombudsman concerning the European Securities and Market Authority, which was a case was concerned with a breach of duties relating to incorrect application of substantive and procedural rules in competition and selection procedures, because this agency's decision to reject compliance application was based on criteria that were not set out clearly in the notice of vacancy. Another agency which has been investigated by the Ombudsman is the EBA, the European Banking Authority, which was criticized and inquired because of the manner in which it selected its key advisory body, the banking stakeholder group. And another inquiry concerning the EBA was on the limitation of access to its websites only to English language, and this would have impeded citizens to access to information. And what is interesting in this case is that at the beginning, this case was presented to the European Parliament's Committee on Petition, then it was somehow moved to the European Ombudsman since it concerned a possible instance of maladministration. As to the bodies, as you know, bodies have always been in the realm under the scope of the Ombudsman competence, so there's nothing new. How do you define a body? The best thing is to look at the name of the specific subject, and one of them has been lately the BEREC, the Body of European Regulators for Electronic Communications, which is the successor of the European Regulators Group for Electronic Communications, which has been investigated already in 2007. Offices. The offices is another new opening, so to speak, after the Lisbon Treaty, in a case concerning the offices for harmonization in the internal market, trademark and design. There was an inquiry of 2007, so even before the entry into force of the Lisbon Treaty revision, which makes clear that the interpretation of the term bodies by the European Ombudsman, even before the formal introduction of that word in the basic rules concerning the competence of the European Ombudsman, is very, very, very generous. I don't know where to put the European Ombudsman in this list, actually. I guess it will be in the second. It's a body, probably. I'm not sure that the European Ombudsman has a competence to investigate on its own administration. This is a question I'm posing to you. It probably should be, and possible control also in the Ombudsman way of dealing with its own competence as far as the administration is concerned, but I'm not aware of any inquiry opened by an ombudsman against the ombudsman. The extension of the mandate to the European Ombudsman via other provisions, which are not directly related to its activity. The first important point is that the European Council has acquired the status of an institution via the Lisbon Treaty revision. Therefore, its activity now falls in full within the scope of European Ombudsman mandate. And this has increased considerably the legal accountability of the European Council, which, as we know, is rather limited as far as the intervention of the courts is concerned, in particular when the European Council intervene in the context of the previous second pillar. And in fact, lately the Ombudsman has inquired the European Council for different questions concerning transparency, questions concerning the use of service card by the presidents of the European Council, and so on and so forth. As to the matters included in the European Ombudsman mandate, the abolition of the pillar system has broadened again the scope of action of the European Ombudsman, covering also the former second pillar. With Amsterdam, it was extended to the third pillar, with the Lisbon also to the second pillar. Here encompassing complaints falling under the common foreign security policy and the common security and defense policy. Just to give you a couple of examples, the case 12/2010 on inquiry of the Ombudsman concerning the European External Action Service, open and closed in 2013, concerning the issue of accountability for instances of maladministration in the activity submissions carried out within the context of the common security and defense policy. Another example, more recent example, in 2014, when the Ombudsman, again, at their own initiative inquiry, investigated on the European External Action Services, the way it handled allegation of serious irregularities involving the EU rule of law mission in Kosovo. It is important to note at this juncture that the extension of the mandate to European Ombudsman may have positive, although indirect, effects for the protection of individuals, to counterweight the exclusion of the jurisdiction of the European courts in the same field. it is widely accepted that the notion of maladministration is very broad. It goes beyond cases where the rule or principle is legally binding, but still encompasses the violation of prescriptive rules. It is true that in general, recourse to the European Ombudsman does not have the same advantages for individuals' rights as direct access to courts. But in any event, for instance, in case of a decision of the European Council not to disclose a document in the common foreign security policy in violation of the principle of transparency may be attacked only via an inquiry of the European Ombudsman. This is very important. And the same conclusion applies, even though in a different context, for cases where individuals may not have access to the courts according to the limitation in Article 263, paragraph 3 of the treaty, the way it is interpreted by the Court of Justice. Of course, the important innovation of the Lisbon Treaty is to give the Charter of Fundamental Rights a legally binding force, and here I should mention the fact that the Article 43, paragraph 3 of the Charter recognizes the right to refer to the European Ombudsman as one of the fundamental citizens' rights in Title V, and this not only confirms the value of primary law of reference to European Ombudsman, but also acquires the status of fundamental rights. One may wonder how fundamental is this right, since no chance is given to a complainant to challenge the decision of the European Ombudsman or its inactivity, but this will bring probably us too far today. The same happens for the principle of a good administration, which is obviously the main point of reference in the activity of the European Ombudsman, including the right to be heard, to receive recent decisions, so on and so forth. The question here concerns the material scope of the fundamental right to refer to the European Ombudsman. Access to the Ombudsman is still considered as a part of European citizenship, Article 20 and 24 of the treaty, while Article 228 and Article 43 of the Charter extend the right to refer to natural persons residing in the European Union, as well as legal persons having the registered office in the European Union. Such provision therefore exclude that the inquiry of the Ombudsman may be triggered by an extra EU national or by a company not established in the European Union, even though obviously this person may be negatively affected by a maladministration on the side of European institutions, body offices, and agencies. It is true that if I understand correctly, the statute of the Ombudsman and its implementation in practice, it is not required to have a personal interest in the complaint. In other words, the limitation provided by the treaty only concerns the natural legal person that actually introduces the complaint, which in principle could involve the situation of a different person, including a third country national or a company registered outside the Union. And the European Ombudsman is probably conscious of this problem, since it decided to give a very broad interpretation of the notion of residence in a member state and of legal person. It also opens at her own initiative inquiries where the individual complaint is inadmissible due to the subjective rules just mentioned. But still, there are cases of maladministration that may never come to the attention of the European Ombudsman because of the subjective limitations enshrined into the treaty. And given the importance of the activity of the Ombudsman in the general context of the protection of individual rights, I would welcome the textual extension of the fundamental right to everyone, as is the rule in any international charter or treaty concerning the protection of fundamental rights. Obviously, this requires a treaty revision, but we already have Article 41, which is into the chapter of the Charter dedicated to citizens' rights, where no limitation, no such limitation can be applied, where there's a direct reference to every person rather than to every citizen of the Union. The second problem is the objective, so to speak, limitation of European Ombudsman mandate, which excludes, based on the treaty rules, national administration. whereas it is well known that the administrative implementation of European Union law is largely the responsibility of member states. It has been suggested to interpret Article 43 in the light of Article 51 of the Charter, which, as we know, extends the application of the Charter to the activities of member states when they act in, when their activity is based on European Union law. The Court of Justice in July of last year adopted a literal interpretation in as far as Article 41 is concerned. Also there's a direct reference to the institutions and of the Union to define the scope of application of Article 41. And the Court of Justice in a Greek case concerning the procedure for asylum came to the conclusion that the Article 41 should be interpreted on the basis of the text. Still, the problem remains on how to foster uniform interpretation of good quality administration in cases where national bodies act as longa manus of the European Union. It is true that the general principle of European Union law lying behind Article 41 also apply in domestic situation. Therefore, in parallel cases, it should be the task of national regional ombudsperson to intervene. But unfortunately, the task and the powers of the various ombudsmen vary from member state to member states and might not be as effective as recourse to the European Ombudsman. For instance, Italy does not have any national ombudsman office. And God knows how much we will need that. What will be the solution? Probably reinforcing the network of national ombudsmen following mutatis mutandis, the National Competition Authorities Network model. Finally, come to Article 47 and the judicial review, which can be taken into consideration from different angles. As I mentioned before, the limitation to access to court can be somehow counterweighted by access to the European Ombudsman in all cases where the individuals may not have a case before the Court of Justice. As you are aware of, lately in April 2015, the Court of Justice gave a rather strict interpretation of the new provisions introduced by the Lisbon Treaty on Article 263, paragraph 4, as far as the individual's access to court is concerned. And this, on the other side, gives the European Ombudsman an important role as to defend individual rights in its own limited competences where courts cannot intervene. As to the judicial review of the activity of the European Ombudsman, this is another interesting question because what we are witnessing lately is a different approach of the courts, of the European courts, to the question of review of European Ombudsman decisions or inactivity if compared to the approach that the court has chosen in the parallel question of access to the courts against the European Parliament committee decision not to not to consider a petition. In the second case, the court admitted that should be a jurisdiction. There should be a review of the court when the petition committee decides not to accept a case. The same is not true for the European Ombudsman. Even in a very recent judgment, the Court of Justice has decided that since the European Ombudsman is not empowered to adopt any act which affect third parties, including the complainant, it is not possible to have recourse to a judicial review. And finally, an important step forward, probably influenced by the importance that the principle of transparency has received in the Lisbon Treaty revision, is when the European Ombudsman decides to extend the principle of maladministration to legislative procedure. And this is the case of disclosure of documents adopted in the trilogues procedures and concerning transparency of trilogues in general. In May of this year, the Ombudsman opened an own initiative inquiry concerning that specific, very delicate situation. It is not obvious that the treaty covers also legislative procedure, but as always, practice is the most important answer to this question. If the other institution accept that the European Ombudsman control may have this extension, then the question is probably automatically settled. And let me just move very shortly to the European Citizens Initiative. This is again a gift from the Treaty of Lisbon, that the new instrument according to which a number of at least 1 million citizens may try to intervene in the delicate phase of the adoption of a new legislative proposal by suggesting to the Commission to introduce a new draft, a directive, regulation, or whatever. This is a case of an important case on how the European Ombudsman has interpreted its role as far as it's a general intervention to avoid questions of maladministration is concerned. It is not new, actually. These general questions, the general inquiries concerning the activities of the European institutions has some important precedents. Let me just mention the 1996 inquiry concerning the access to documents, which has in practice suggested the institution to adopt Regulation 1049. In the following year, let me remember the very important initiative of the Ombudsman concerning the infringement procedure. That was very much needed, that the activity of the Commission in the administrative stage of the procedure should be more transparent and more complainant-friendly, so to speak. But after the entry into force of the Lisbon Treaty, one may note a change of approach. Apparently, the European Ombudsman does not base its general inquiries on the presentation of a number of complaints. It makes no reference to the fact that it has received, or at least it does so, but very general statement, received complaints for maladministration to open a general inquiry. And this is true, for instance, in the case of the inquiry concerning the transatlantic trade and investment partnership negotiations, the inquiry concerning transparency of trilogues that I mentioned, the second inquiry on timeliness of payments to the European Commission, so on and so forth. As to the ECI, the Ombudsman decided to intervene in the procedure, which brought to the adoption of Regulation 2011 or 211 of 2011, and with two objectives. The first, to ensure that the current regulation is applied correctly and in a citizen-friendly way possible. The second, to provide input to review of the ECI regulation. So the Ombudsman intervened both in the moments of drafting the regulation and afterwards in highlighting some critical aspects of the procedure with a view of suggesting to the Commission to intervene and modify the procedure. So the European Ombudsman has started again an inquiry of her own initiative in 2013, has opened an investigation which received a number of feedbacks from interested parties, and in January 2014 invited the Commission to take a stance on this on this inquiry. At the end of the procedure, the Ombudsman adopted a decision by which she suggested 11 guidelines for further improvements of Regulation 211, distinguished on the basis of the stage of the procedure, the preparation stage, the admissibility stage, the examination stage, and finally collection of support. Since I participated in one of these procedures, was involved in the drafting of one of these citizens' initiative, the one concerning pluralism in the media in the European Union, which did not reach the number of supports. One thing that I noticed in the context of this procedure is that there's a lack of information. There's nothing in the regulation which requires member states to make as much as possible inform their own citizens and the citizens of other member states that there's a pending initiative at the level of the European Union. And probably I may suggest to intervene into the regulation in order to require member states to make this initiative as much as possible open to media coverage, because we found out that it was rather complicated for the committee to substitute themselves to the role of the mass media in making this information available. So the European Ombudsman closed this inquiry in 2014, and in March of this year, the European Commission adopted a report as required by Regulation 211. Basically, the European Commission is saying that there's nothing that deserves an immediate change, even though it took into consideration the suggestions of the Ombudsman. It concluded that the system is working rather well. There could be some need of improvement, but nothing which justifies, in general, a revision of the basic regulation. And finally, thank you for your attention.
So again, we can open the discussion onto a very inspiring paper. Yes, first of all.
Thank you, Fergal O'Regan. I work for the European Ombudsman. Roberto, you made a comment about the trilogues inquiry, and if I understood it correctly, you referred to it as examining the legislative procedures of the three institutions concerned. I think there's a misunderstanding, in my view, as regards that statement. The trilogues inquiry concerns the transparency of the process, the specific choices of the institutions as regards how they conduct the legislative procedures. I mean, trilogues, ad hoc trilogues, are choices by the institutions as regards how to arrive at agreement by first reading. The Ombudsman does not call into question the choices, the legislative procedures, as you call them, of the institutions. The purpose of the inquiry relates to the transparency of those procedures, which are clearly based on the obligations under the treaty, specifically relating to Parliament and the Council. When they legislate, obviously must do so in public according to the treaties. And as regards the competence of the Ombudsman on that specific question, I think of all areas, clearly the issue of transparency, access to documents, whether it be in terms of request for access or proactive release of documents, is an area where the Ombudsman has specific competence under Regulation 1049. So I would clearly reject any view that the Ombudsman is entering into any question of the choices made by the legislator in terms of how it conducts the legislative process, and clearly state that when the Ombudsman is looking at this issue, it's about transparency, and that clearly is based on a normative base, but also clearly falls within the competence of the Ombudsman. Maybe just one suggestion, just to add on to another point. You refer to institutions, bodies, offices and agencies and the competence of the Ombudsman. Of course, those terms are mentioned 3 places in the treaty in relation to access to documents, in relation to the competences of the court. It refers to the jurisdiction of the court covering institutions, bodies, offices and agencies, and in relation to the Ombudsman. There was an opinion of the Advocate General in L'Italiana versus Ulex Kosovo on the 21st of May, which suggests also that the missions, you referred to the Ulex Kosovo case where we examined it by carrying out an inquiry versus the External Action Service. At least the Advocate General in that particular case seems to suggest that it's even broader, covering possibly, if you follow the Advocate General, the missions themselves. So Ulex Kosovo would fall under the jurisdiction of the court, and obviously, since the same terms are used vis-à-vis the Ombudsman, could possibly in future cases fall directly under the competence of the European Ombudsman.
Yes, thanks, Fergal, for clarifying that. I remember there's a story told about a Canadian ombudsman many years ago. He was famously a member of the Royal Canadian Mounted Police and a Mountie. And he said one time that he'd never actually read his statute. And when he was asked why, he said, well, so as I'll never know whether I'm outside my remit or not. Just for the record, I have read the statute. And I know there's sort of some suggestions perhaps, and not just what you've said there, but other commentary about some of the new investigations we've started, that there's a little bit of mission creep or whatever. I still like to call it mission. In relation to the ECI one, I think at the end you seem to suggest that there was some sort of the Commission to some extent dismissed it or didn't think there was anything worthy of significant change. But I think what I was trying to do there was, I saw that the ECI was brought in with a great flourish, meant to be this big piece around democratic legitimacy and so on. And then I and many other people who take an interest in European democracy and so on, and the role that a citizen can potentially play and should potentially play, felt that the initial way that the Commission was dealing with this was quite dismissive. And so I suppose really what I was really trying to get at in that investigation was to explore how the Commission should properly respond to 1 million signatures from people from seven from 7 countries. And so in a way, a lot of the recommendations that I made weren't particularly, major or whatever, and a lot of them may have referred to technical issues and so on. But I think at the core of it was trying to influence the Commission, along with other influencers, to take the ECI a lot more seriously than it had been. Because if that doesn't happen, then the ECI, people will lose belief in it, they'll stop going to the effort of producing ECIs. Maybe that ultimately is the political will of the EU, that this shouldn't really become a part of the legislative procedure. But I noticed after, I think there's one of the ECIs, I think on vivisection has just got across the line, and I noticed that the Commission is responding to that in a much more full way than perhaps it has responded to others in terms of the inquiries and hearings and all of that it's going to do in relation to it. In the context of the ECI, I saw myself as Ombudsman as one influencer among many that were seeking to make sure that something that had been inserted into the treaty as a way of increasing the democratic legitimacy of the European Union vis-à-vis its citizens was taken seriously.
Thank you. Jacques?
Yes, a foible of mine, which is languages, something which Roberto said, which triggers a question to Jan Harden and his colleagues. Because bodies, offices, and agencies is in the English version. and it creates more problems than it solves, because in French or Italian it's organisme, and organisme can be anything. My question is whether there have been requests or complaints to the Ombudsman due to the difference in languages, not to speak about the fact that so many offices and agencies do not do what the Ombudsman does, which is have web pages in all languages when it's necessary. But other questions which came to you due to the fact that there are discrepancies between different language versions of, well, hard law, communications, God knows what.
Very briefly, yes. From memory, I remember one case in which somebody complained about that a text, I think, was it in Latvian? The Latvian, was it the Swedish version? Was incorrect, and it was presented as a complaint against the Parliament, I believe, and the Commission, and we sent it to we sent it to the Commission, and the Commission accepted that there was an error in the translation and undertook that it would indeed correct it. So yes, we have had such complaints. I'm not aware, my colleagues will correct me if I'm overlooking something, that we've had any confusion resulting from the difference between the different language versions of offices, bodies, agencies, organismes. I'm not sure that we've had any problems of emerging from that.
Roberto,
Well,
would you like to answer a few minutes, just the various comments?
As to Fergal's comments, I agree. I mean, I was just having this doubt because my point is that there should be no aspects of institutional life without accountability. So if the European Ombudsman believes that it can extend or apply whatever its intervention to also to parts of what is admittedly a legislative procedure. Trilogues is a part of legislative procedure. I am more than happy, because otherwise there would be no other form of control. So I totally agree with you. I mean, this should be I mean, it reminds me on when in the 70s European Parliament has extended its own competences, even probably beyond the mere letter of the treaty, and that was accepted. Yes, sometimes with some difficulties, but was accepted by the other institutions. So I'm happy that this is also the case of the European Ombudsman. I still believe that that procedure is difficult to qualify in 100% as an administrative procedure, since it goes somehow into the realm of the legislative procedure. But again, I agree. As to the Mrs. Reilly remark, when I read your letters, your positions vis-à-vis the Citizens' Initiative, I was struck by the intensity and the how deep the investigation was. Again, because I have been participating into one of this procedure, and I found that the Commission, if I can use a very informal word, is not really happy with any sharing of its role of the sole body entrusted with the adoption of a draft proposal legislation. And this is clear. And this is clear vis-à-vis also the European Parliament. The resolution of the European Parliament, lately the one on the codification of administrative procedure, have not been followed by the Commission, even though they are adopted on the basis of the treaty article, which gives the European Parliament the power to suggest. And so I'm again, I am very happy that the Ombudsman has taken this route, and I see, reading the report of the Commission, that they are still very conservative on any improvements on of the procedure. The question of Jacques was not for me, it was for you, so it was already answered, so I'm okay.
Yes, please.
Could I just suggest, Professor Mastroianni, that you complete your mention of the interesting articles in the Charter for the Ombudsman's role with Article 42, because I've been a bit stimulated by the remarks made about the role of review and so on. And what I've got in mind is the fact that, and Alan mentioned this earlier on, in the Bavarian Lager case, that was before the Charter. The Charter existed since 2000, but it wasn't being enforced by the court. And it wasn't being mentioned by the court or even by any of the parties in the Bavarian Lager case. So the only human right that was being talked about in the Bavarian Lager case was Article 8 of the Convention of Human Rights, the right of privacy. So what was not talked about was Article 42 of the Charter, the right to public access to documents. It's a fundamental right. And now after Lisbon, after a directly applicable right, and Article 8 of the Charter, the right to data protection rather than the right to privacy. And the balancing of those two rights, I'll come back to that in a second, I think should make a difference to the result of how that case would be treated now. It would make a difference in part because of the case law of the court, which has made it plain that the fundamental right to data protection includes the protection of other rights. So you have the Google Spain case, where one of the few things the Advocate General and the court agreed on was the balancing of fundamental rights against the right of data protection. So if I go back to Article 42 and I say we should apply that now in a case like Bavarian Lager, back in 2002, the Ombudsman made it plain that there was a good reason for the request for the documents. There was a suspicion of corruption at the national level. That was in a document produced in a letter by the Ombudsman to the President Prodi, which actually had your initials on it, Ian, and IHG and GG. So I assume you had something to do with it. But the reason was plain. So I think the difference it would make now is that you would apply Article 42 and you would interpret that to Regulation 45 and the right of data protection. You'd say, there is a reason. Mr. Ronan doesn't need to produce it. It is known. And the Commission should apply it and should have given access to the document. So the entry into force of the Treaty of Lisbon, I don't think people fully appreciate the impact of making the right to access to documents an enforceable fundamental right in the balance with other rights. So I'd strongly recommend you to add it into your panoply of wonderful things in Chapter 5.
May I make questions other than answers? No, I was just wondering, I put this point during the presentation on quis custodiet custodes. Who controls the controller? Who controls the European Ombudsman? I mean, this is a problem that is arising at the Court of Justice lately concerning the cases of non-contractual liability European Union for damages caused by the decision of the court. Who should decide on these cases? Judge Rosas is probably more aware of this problem than I am. So I have this curiosity, so to speak. Who controls the European Ombudsman? So I will not be invited. Jesus, again.
Well, with this, I think we should go and, no, Ian, you have a last remark before the coffee break.
Just very briefly on that question, of course, the court controls the Ombudsman. There are cases in which the court has awarded damages against the Ombudsman, including one very recent case. There is a procedure for dismissal of the Ombudsman. There are a number of procedures within the office by which anybody who writes to the Ombudsman and who says, Ombudsman, you've dealt with something badly, you've done something wrong, or please do this, will get an answer. It will be a substantive answer and a reasoned answer. There are specific procedures of requests for review of decisions, service complaints against people who've handled complaints. We have a two-stage procedure with for access to documents, with the initial decision being made by the Secretary-General, this confirmatory application dealt with by the Ombudsman. So in substance, everything which I think you could expect and want is there. What we don't do, or what we've not done in the past, is to say we're going to register a complaint against the Ombudsman as a complaint under Article 228 of the treaty, and the Ombudsman will deal with it. Even if that were legal, which I don't think it would be, it's not very elegant. But in substance, that's what happens.
Good. With that, I think we should have a cup of coffee and a cup of tea, and we'll have more chance of debate after that. Thank you.